If this were not a high-profile case, you can go do your own research. There have been at least 10 cases recently where the resentencing takes place and the inmate is released immediately.
Thomas, I have this mic too.
Yeah.
For those of you who weren't in the courtroom, what was ultimately decided is we are filing a motion to recuse the district attorney in this case. We set a date of May the 9th. The family does not want to go through this charade anymore with the DA. They are going to, I anticipate, the motion hasn't been written yet, but given what transpired today and given what's obvious to anyone, I think, who has a couple of synapses that are still firing, this is a DA who made up his mind and did no hard work in terms of his position. He is vindicating no one's interest. He hired a lawyer who endorsed him as his head of victim services. He has given absolutely no victims services whatsoever to the victims in this case. He has taken a position at all times that is not supported by the law. It's not supported by the facts. In addition to that, as everybody already knows from last time I've talked about it, the two deputy DAs that he had, that he inherited from the previous administration, he gave freeway therapy to one, Mr. Lunsford. By the way, for those of you who are in the weeds, when Pam Bozanich lost by having a hung jury on the first trial, she was banished to Norwalk and was not allowed to try the second case. When Brock Lunsford made the cardinal sin of following the law and the facts and initiating a resentencing for the Menendezes, one of the first acts, even before he was sworn in, was to banish Brock Lunsford to guess where? Norwalk. I don't know what's the matter with Norwalk. I'm sure it's a very nice place, but if you end up there as a DA, that's not exactly the pinnacle of your career. Nancy Thieberge, who had a very illustrious career in the DA's office, he actually kicked out of the office. John Lewin, who spent 18 months as a commentator, anybody that would put him on TV during the previous administration, criticizing the Menendezes, was promoted to major crimes, which is the plum assignment in the office. Habib Balian is his direct supervisor as the assistant head. You now have in addition to all of that, you have Mr. Hochman taking positions and doing press stunts that, in my humble opinion, not only violate his duty to the law, but violate his duty to the state of California, the county of Los Angeles. The ultimate insult, I believe, was last Friday when the grisly crime scene photos were thrown up unexpectedly in violation of Marcy's law, which, as Mr. Friedman ably pointed out, is a constitutional provision. We believe that directly caused the re-traumatization of Terry Baralt, who I'm happy to inform is now out of the hospital, but was found unresponsive. Mr. Hochman's solution, or his answer to her being traumatized, was at best weak-kneed apology, and to promptly have Kathy Cady, his supposedly walled-off head of victim services, arrange a rather failed protest at which he spoke on that Sunday morning while Terry Baralt was in ICU. Mr. Friedman has also articulated today, on behalf of the victims, further grounds for recusal, but all taken. The standard for recusal in this state under Penal Code Section 1424 has been met. We plan on filing that. I would have done it sooner, however, I wanted to get this hearing done. Unfortunately, to recuse a DA's office requires 10 court days under the code, and you have to give notice to the Attorney General. Anticipatorily answering some of your questions, I would suggest you ask Mr. Bonta what his position will be as the Attorney General and the Chief Law Enforcement Officer of the state. Yes.
Is it your contention that the DA is biased in this case?
Yes, under a recusal motion, so that you understand, is that there is the appearance of impropriety and actual bias and on behalf of the DA. Anybody who witnessed him driving out here from the West Side enclave where he lives to do a press conference this morning to say nothing except to violate what was then a confidential document in front of the cameras and then to scurry off, I think would be probably Exhibit 27 of the motion to recuse.
Where is the bias?
It's not just, what's the what?
Where is the bias?
Okay, if you don't understand the bias, you'll just stay tuned and we'll read.
Well, Mark, you brought up Beverly Hills High School. You brought up that he's from
I didn't bring up
Hills,
Beverly
but
Hills High School, Mr. Kovacic. Mr. Friedman did, give him credit. I brought up, everything I just detailed is what I brought up. That will be part of the
But does
motion.
that come into play here? That
Everything is fair game. When you do an analysis, based on the analysis we have done, based on recusal motions, which I have filed in the last 25 years and won in this county, this is about as righteous a recusal motion of a DA that I've ever had.
Mr. Geragos, this for your client.
This is now the third time we've had this
Do you want the comprehensive risk assessment admitted to the court or not?
I haven't seen it, so I don't know how to answer that question.
This is the third time we've had. This is the third time we've had this resentencing hearing postponed. How is the family feeling right now?
Well, let's be accurate. Friday was not postponed. Friday was the hearing on whether they could withdraw. Yes, you're actually right that November 25th was postponed. The family did not want that. I didn't want that. You are right that it was postponed due to the wildfires. Obviously, that was something that severely impacted Southern California. Today's is, as a matter of law, you have to give 10 days court notice.
Mr.
Mr.
Geragos, can I ask you and the family, sir, are you now resigning yourselves to the likelihood or possibility that the earliest decision on release, freedom, could be post that parole hearing in June?
No, I'm not at all.
How is Erik and Lyle feeling after what happened in court?
I haven't talked to them after the last thing. Obviously, they're cautiously optimistic. I mean, there are a lot of reasons to believe that when we do the resentencing hearing, that we will get Judge Jessup to reduce this to a manslaughter and release them on time served. That's what the goal is here. The goal is not, as I stated in court, to get a 50 to life and to convert this into a parole hearing. The goal here is very simple. If this were not a high-profile case, you can go do your own research. There have been at least 10 cases recently where the resentencing takes place and the inmate is released immediately on LWOPs. That is not unusual. If it wasn't for all of our accumulated masses here, that's what would have happened in this case. But because it is